and as soon as it says it's gone live, hey, look at that, we're live, holy crap. And now we're officially an on-page show because we're like 2 minutes late in starting.
Yes.
So good for us, right?
Yes, and Jason, your screen is black.
My screen is black.
Yep.
That is awesome. That's frustrating.
Yep.
Technical issues.
Mm-hmm.
I guess I'll have to reload again.
It was bound to happen at some point, wasn't it?
Eventually, yeah. Tech issues always happen on the home page. We've just been lucky so far. So good evening, everyone. Welcome to Attainable Advocacy. I'll be right back.
Actually, I think we're still on our 30-second countdown. Or maybe not. Oh, no, we're not.
Oh, no, we're very much live.
Yes.
This is how you know it's a live show, because things are screwing up right away.
Mm-hmm.
Beautiful.
Okay, everybody in chat, have a good laugh. First technical issue.
Yep, first technical issue, and it's with the guy who's running the Hangout. That is always a problem. So, as I said, good evening, everyone. Welcome to Attainable Advocacy. I am Jason Downing. I am the other guy who is not blowing smoke. Stefan Didak is with me as always, and we have... Oh wait, I'm sorry. We have to announce him properly. The Borg of Advocacy is in the house, and joining us tonight for a chat about intellectual property is John Challis. He is a practicing intellectual property attorney, specializing in trademark and what? Patent, right?
Trademarks, patents, and anything anybody else will pay me to do. How you doing, guys?
Pretty good, pretty good. So, John is actually an attorney, we promise, and for the purpose of this Google Hangouts, he is also playing an attorney.
I do both.
With that said, let's get this out front. Yep. Hey, this is live. Let's get this out of the way right now. Stefan and I are not attorneys. Nothing that you hear on tonight's show should be construed as legal advice, because even though John is an attorney, he is not your attorney.
At least
you
not
can make checks payable to internet.
Right. But, as usual, before we get into the main topic, let's talk about some news. So, Minnesota, today, there was some news. And there was some news courtesy of the House Tax Committee, which voted to include in the omnibus tax bill a 30-cent per milliliter tax on e-liquid. This is despite testimony from 40 different people in opposition and 6 in favor of it. 6 to 40. That's almost 7 to 1, just for the record. And funny story, the author of the amendment that made that happen actually had a little comment on this to some of the other folks, and it was his name is Representative Greg Davids. He's the chairman of the tax committee in the House in Minnesota. 40 opposed and 6 in favor of, and David says, what if you take out the vapors?
Head desk, head desk, head desk, head desk.
Just for the record here, I would like to point out that Clearway, Minnesota is our normal opponent in a lot of these. You will notice right here that Clearway actually tagged the MN Vapors Twitter account, which I run, as well as Alex Carlson, who is one of our advocates here in Minnesota, to let us know about it. Clearway is actually opposed to this bill, so is Americans for Non-Smokers' Rights, and all of the normal people that you would expect to be against us. They are actually opposed to this bill because it helps out Big Tobacco, to be honest. Big Tobacco was very threatened by vaping, apparently, to the extent that last week when the tax committee took testimony, they actually sent Fred Ampolini in, who, if you don't know who that is, he is the president of R.J. Reynolds Vapor, a.k.a. Views. You may have seen a video or two about them last week. So, a little interesting, I feel, that a Republican would go after small business and try to increase taxes. It's not usually their MO, but that's what we have right now. So this bill is on its way to the Ways and Means Committee. We are still very hopeful that we are going to have a good shot at taking that terrible amendment out, because frankly it would destroy every single shop in Minnesota. That would be 70 plus small businesses out of business and several hundred jobs. So that's a good time. But again, with that said, we're very hopeful that we can defeat that amendment, that bill. Well, not the bill, that's the omnibus tax bill. We can't defeat that. It's kind of a must pass. But we are hopeful that we will see some movement on that in the coming days, and keep an eye out on mnvapors.com, and I'm assuming that CASA will probably have a call to action in there as well. And if you are not currently following Minnesota Vapors Advocacy, you can find us at facebook.com/ what is our page anyway? I was all set to go, and wait a minute.
Whoa, we have a page?
We're just gonna drop there's the group in chat, and then that's the page. And while you're at it, you can also go follow these guys, who are the Independent Vapor Retailers of Minnesota, which is Minnesota's trade association for vaping business. All three of those are going to be good resources and places to get info, and otherwise, that's all for Minnesota for right now. But more to come. Stay tuned. Keep an eye out. I'm going to hand it over to Stefan, because I'm sure he's got some California stuff or some other non-California stuff. We can probably talk about Indiana again, since that's still an issue.
California stuff. Okay, so did the hearing for SB 24 last week. It was a mile of difference between SB 140 and Leno, because Senator Hill was actually quite reasonable. Took in amendments, got an exemption for vaping in vape shops.
You mean he didn't rush you with a full copy of the bill?
No, actually, he was very kind. I mean, afterwards he actually shook my hand and said, "Thank you for your testimony," and then left everybody from the public health groups just sort of standing there. I guess it's a political signal.
I suppose they must not let the body. That's the body parts people, right?
The body parts people, exactly. So the bill goes fairly far in separating vapor products from tobacco products, which is exactly the way we like it. So I had a pretty long day in Sacramento. Then apparently ended up pissing off a professor. And honestly, I have no idea what I did, but I was just wearing a Svada t-shirt and used it in a picture in a frame, and now Professor Glantz is urging Svada to, or rather urging Mitzeller to bail out of the Svada conference because I made a cessation claim while I was wearing a Svada t-shirt. In the meantime, Professor Glantz apparently completely forgot that I'm not an industry stakeholder. I'm actually not selling anything. So,
That's terrible.
Yeah, I must have gotten under his skin in some way. Don't know.
Well, there's plenty of it to get under.
Ouch. Hey,
Yes.
let's be fair here. We don't need to stoop to ad homs. We're better than that most of the time.
Speak for yourself.
Fair enough. Fair enough. Yeah, you're not in California. What do you care, right?
Oh well, I don't care either. I mean, let's face it. 2 attacks aimed at me in like 1 week. Wow.
I mean, that's pretty impressive. You're obviously doing something very right or very wrong. I'm not really sure which.
I'm not sure either, but the only question I would have is like, so how is it being on the defensive all of a sudden?
Here's what I find really funny is you have Professor Glantz attacking you personally and publicly. I can't even get my state rep to respond to me via email other than with a form letter.
Well, I guess the main ingredients are, 1, we need a nut blowing smoke campaign in Minnesota. Just saying. 2, you need a CDC tips campaign in Minnesota. man, you need Professor Glantz in Minnesota, and guess what? You can have it.
That's the problem, is we don't really have anybody like him here. I mean, we have Clearway and ANSR, but I mean, honestly, that's really most of the time they're just the run-of-the-mill stuff. It's the usual, like, oh, there's not enough long-term study, and kids, and flavors are bad, and all of that. But otherwise, I mean, like, there's misinformation, and then there's misinformation.
Well, we're happy to share our glance with you. I mean, there's enough of him to go around.
Oh, man, again? Really? Really? Come on.
Next time I say something about vapor and have my picture taken, I'm just going to make sure I'm wearing a UCSF shirt.
You know what? I bet you we can get you a hoodie.
Wow. That would really be great.
See, the only way that could have possibly been better is if you had gone to school at UCSF.
Wow, and end up brainwashed?
Well,
never really took to that.
I don't think you'd be
well,
brainwashed.
Sort of depends. It depends on the department, of course, right? Yeah.
Oh, let's be honest here. You wouldn't have gone to school for public health. Come on.
You go to school for that?
Apparently.
Oh, okay.
I mean, there's no medical. There's no medical.
Right? I think it's mechanical engineering for public health.
Yeah, I was gonna say there's no medical knowledge required to be a public health advocate. It's fine.
No, apparently, yeah. Yeah, that's true.
What else do we have? Indiana. Indiana's still a problem. If you guys live in Indiana, you should go do the CASA call to action and veto a really, really awful bill. You guys vaping, and I hope you do. That would be a good oppose if you have. For anyone who doesn't recall from last show, among other things, basically casino-style security requires access to the mixing facilities, 24/7 third-party monitor surveillance with 30-day backup, and 3 10 ml samples from every single batch of liquid.
I'm just checking with chat to see if your audio broke up, because you broke up like in the typical robot voice.
Oh, great. That's not good. More tech issues, huh? I don't even have anything extra going beyond
Yep.
on my screen right now. That's the bad part.
Yep. Yep. Chat's informing us that you've got a robot voice.
Well, I guess we can solve part of that problem. I'm just going to turn off my camera for a second and see if that helps. So you won't get to see my smiling face, but that's okay because Stefan's prettier than I am anyway.
Woo! Well, Stanton Glantz apparently thinks so. I mean, he's really in love with that picture of mine.
Hey, you're the popular kid right now. So, what else do we have for tonight? Do we have any other news that we want to talk about? Chat, is there anything you'd like to hear about? You can interrupt us at any time, even though you're on a delay.
30-second delay.
Yep.
I'm monitoring things.
In the meantime, I think we should start talking about intellectual property, because that's fun. What is intellectual property? What's a simple definition of intellectual property for people who aren't aware?
Well, first of all, I think that's the first time ever that anybody's ever called intellectual property fun. But intellectual property, first I'll introduce myself. As Jason said, my name is John Challis. I'm an attorney in St. Louis, and I am, in addition to being a practicing attorney, I'm also the legal director of the Bi-State Regional Advocates for Vaping Education, or BRAVE, which is kind of the Missouri grassroots nonprofit advocacy organization. Intellectual property really kind of encompasses 3 different and distinct areas: patents, copyrights, and trademarks. You can also throw trade secrets in there, but typically it's just considered patents, copyrights, and trademarks.
We like secrets.
Secrets are good.
Especially.
So, in the vaping world, we probably deal with two of those regularly, right? I mean, there's a couple of patents floating around out there, maybe some that are applied for, but for the most part, it's really just trademarks and copyright.
Yeah, I mean, really the biggest one that has come up that I've had experience with is trademark, and really, you know, the way you can kind of think about them differently is the let's take a Nook, okay, for example, just to kind of give a good concrete example. The Nook itself is an Amazon product, and Amazon can trademark the name Nook. The product itself, the design of it as well as the working of it, can be patented, and then the content that you read, the books themselves, can be copyrighted, and that copyright can be held by the author of that book. So that's kind of the easiest way to distinguish between the three different areas of intellectual property law. Like I said, really the biggest one that we come across in the vaping space tends to be trademarks. There are not a lot of patents out there. I do think that is something that is going to change over the next couple of years. I know that Evolve has some patents out there, and I know that they have some pending patents. But really, when you think about it, although the technology as we think about it is relatively new, the actual atomization technology is relatively old. And in order to get a patent, you have to come up with a new invention. And so it's going to be pretty difficult to patent anything, even if it has different variations, because it's, you know, essentially all the same thing, which is the atomization of a liquid. So patents we're not overly concerned about at this point. Copyright, people a lot of times confuse copyrights and trademarks. Copyright really goes to content. Think lyrics of a song, think words of a book, think software code. So that really doesn't come into play too incredibly much in this world. Trademarks, which typically cover names and logos, as well as packaging, that is really the big one that comes up a lot in this area.
And as Chad points out, we're all going to be a bunch of smartasses now because the Nook is actually made by Barnes & Noble.
Oops.
Wah wah. So, in the vaping space, we're mostly dealing with, as John said, trademark most of the time. There's probably something out there where we have some amount of copyright, but mostly trademark is really where we're going to be. And that's actually what we're going to talk about tonight, is some of the intellectual property issues in vaping. And we have some visual aids tonight because, well, we need them. It's helpful. And we're going to start with some examples. And just be clear up front that this is not intended to go and beat people up for doing this. It's a thing that happens. Honestly, a lot of people just don't understand these issues because they're not attorneys, or the nature of the internet and sharing things. A lot of people have the impression that it's totally okay to do this. So we're going to start right here with Hellboy.
Ouch. It's a nice dripper, but
the Hellboy dripper is actually... Oh, go ahead, Stefan.
It's a nice dripper, but you have to wonder how long they're going to be able to carry that.
Yeah, I think it's kind of an interesting thing because it's really it's not directly taking characters or anything. It is just a font, but
Right.
it's the exact same font that is used in the logo for the movie. And I just going on a limb here, but for me, if I'm in business in the vaping segment, I am not going to go try to attract attention from people like Warner Brothers or Disney or Sony Pictures. They just don't strike me as the type of folks who would be really fun to have coming after me.
No,
No.
and keep in mind that trademark rights. There's a if I start using a name, so let's just say that you guys are using the name Attainable Advocacy because you are. You actually already have a trademark in that name. You don't have to do anything. You don't have to register anything. You don't have to do anything other than use a name in commerce in order to have a trademark. So you have a trademark. Then the question becomes, do you want to register that trademark? And you can register a trademark with the United States Patent and Trademark Office. It's actually not that difficult of a process. Costs a couple $100. And when you register it, you'll register it for a particular class. And the reason that I tell you this is, so let's just say Warner Brothers or whoever made the Hellboy movie, I'm sure Chad will correct me if I'm wrong, whoever made the Hellboy movie, let's say that they went out and they trademarked that name for use in motion pictures, and typically when someone makes a movie, they will go ahead and trademark the name for pretty much anything, any other related categories that they can come up with, so that nobody could come out with, action figures or toys or, drink containers or whatever else. So usually a lot of times when you get into a product like that, they'll register it across many different classes, and then they can then protect other people and keep other people out of that. But even if a trademark's not registered, you still gain rights in it the more that you use it in the areas that you use it. So, this show is obviously broadcast nationwide. One could certainly make an argument that you now have a trademark in the name Attainable Advocacy, throughout the United States for, a video podcast or a video live hangout, whatever you want to call it. And if somebody else wanted to come up and use the name Attainable Advocacy for that, you could theoretically stop them even if you don't have a registered trademark. So there are millions of cases of trademark infringement a year in all sorts of different areas. The thing that makes the vapor space unique is, one, it is a new space. So there are not a lot of recognized names or recognized brands. And so people, when they're deciding what they're going to call it, they decide to give it a name that, somebody else has already used, or a design that somebody else has already used. It prevents them, and again, I'm not calling out the makers of the Hellboy atomizer, but it prevents them from having to do any sort of creative thinking on their own. I mean, they obviously came up with a very unique atomizer there. Why not come up with their own name behind it as well? Not only does that prevent any potential trademark infringement, but it also gives them a name and a brand that they can protect on their own from other people.
And I think that's kind of the key. You just nailed it right on the head. Is come up with your own stuff. In fact, the name of this episode is "Don't Touch My Stuff."
Yeah, I think that's right. And listen, it's not like it's that incredibly difficult to go find your own name. I mean, like I said, all of these companies are coming up with, well, most of these companies, I'm sure we'll touch on people that aren't coming up with their own designs in a little bit here, but all of these companies are coming up with unique products. Why not come up with their own name? It's really not that difficult. I'm going to drop a link in chat here. This is, let's see, make sure I do this right. I'm in the right chat. So that is a link. It's not going to show up right. Do that, maybe. World Wide Web, not just worldwide. So that is a link to the United States Patent and Trademark Office's what they call their TESS service, and the TESS service is the Trademark Electronic Search System. And you can go on there and you can do a basic word mark search for free on the USPTO's website and see if anybody else is using your name. So if you want to, come up with the Didac atomizer, then you can go on there and you can see if anyone else is using the word Didac for an atomizer or anything else that you think might be close. And then that's a great, cheap, free way to be able to just kind of do some quick searching to see whatever other people are actually out there using. So, it's cheap insurance because it is so much more expensive to have to change your name than it will be to come up with a name on your own.
And I think part of the problem is
I actually
also
just
that a lot of companies in the vapor industry are started by people who simply do not have much business experience. So in a lot of cases, they might not actually even know that they're infringing on trademarks, and they just think this is just fine.
Yeah, I mean, I do think a lot of it is a lack of business acumen. For the most part, a lot of people who are starting these businesses, this may be the first business they've ever started. They were just they're vapors. They're passionate about these products. They want to help other people. They don't have any ill will. It's just that they don't know any better, and it's not going to be until they get that first cease and desist letter from some big company that they're going to learn their lesson. But
and that assumes that they get a cease and desist letter, right?
Yeah, I mean, listen, the way most of these things work, and I send out a ton of these letters and I respond to a ton of these letters all the time. The way that it typically works is, I'll have a client who will come to me and they will say, listen, we had this Hellboy movie and somebody's out there using one of these dangerous electronic cigarette thingies and has the name Hellboy on it. So I'll put together a really nasty letter demanding that they cease and desist from using that name or anything confusingly similar to it. I'll make them do it in like 24 hours, and I'll tell them that they have to pay me $20,000 for my trouble. And that's usually how this process starts. It's pretty rare to jump straight to a lawsuit, although it happens. But a lot of times, I would say that on average, civil lawsuits settle about 90% of the time. In the trademark space, lawsuits settle about 98% of the time, and we can talk about the reasons for that. But these cases get worked out. 98+% of the time, they get worked out. So this process usually starts with a cease and desist letter. The person usually writes back and says, "Oh, sorry, I didn't know I was doing something wrong. I'll change the name." And then all of a sudden, you've got 10,000 Hellboy atomizers out there that you've got to start recalling from stores and everything else and redesigning on the fly when you could have just avoided it in the first place by coming up with your own name.
Or putting no logo on it whatsoever.
But, I mean, to me, if you're coming up with your own unique product, you should brand it. You should try to build some brand equity of your own so that you can start coming up with, and that way, everybody's going to look for the next product from the guy who brought you the Didac atomizer.
Oh boy! How long do you think it'll be before my atomizer's cloned?
I think it actually already is.
Yeah, I'm pretty sure it is.
So let's just kind of move to another example. And these are these are going to be fairly similar, but here's another one that I kind of like. Blatant on this one. This one actually is, I don't recall which company is using it, but they're just directly using the logo of another company that is an active thing. I mean, these candies are actually sold in stores. They're usually in import stores or like world market type places, but they're definitely out there.
Chew.
First of all, I'll say those High Chews are delicious candies. That is a blatant ripoff. I don't even think. I mean, if you now this is funny. If you look in the upper right-hand corner of the logo above the e-liquid bottle, not only did they copy the logo, but they also copied the registered trademark symbol.
Yep.
Which is funny. When you're coming up with your logos for your product, Google Images is not the first place to start. Yeah, that one is just dead on. And listen, one of the other things that you get into is the two of you know better than anybody the pressures that we're up against from the quote-unquote public health groups. But there's obviously a negative stigma out there, and if leaving aside that this is conflated with candy and all of the things that the ants can make out of that, you're going to get into a situation where a company, if you're doing something this blatant, may actually be out for blood and may not just stop at a cease and desist letter, because they may take the position that you are actually damaging their brand name by using the name of a candy on an e-liquid. And I'm not saying it's a case that they would win, but it's certainly not a case that I'd want to litigate.
Well, and even further to that, it's you can make a very strong argument that this is a willful infringement too.
Oh, I don't think there's any doubt about that.
Yes.
Yeah. I mean, so one thing about trademark law, it's a little bit different from patent and copyright law in that really damages, monetary damages, are not the normal relief that you get, even if you win a trademark case. So, if Stefan has his Didac atomizer and I come up with my Dodac atomizer and Stefan sues me and he wins, unless he can really show that I was trying to intentionally trade off of his name, the best he's probably going to get is an injunction against me from using his name or anything confusingly similar. But in this case, where they are so clearly trying to trade off of another established brand name, I think there would be a good case not only for damages, but for an award of attorney's fees and trebled or punitive damages as well. I mean, this is bad.
It's not quite as bad as the next one, though.
Oh, great.
The next one, everyone should recognize. I would say two.
Jason, you cut out.
Damn it.
Yep.
I think everyone should recognize 2/3 of this logo.
Yes. So that'll get you 2/3 of a cease and desist letter, right?
I think it's going to get you in a lot more trouble than that. I mean, I think there's an argument for trademark infringement there, but there's actually also other regulations in play, especially when you start trying to parody federal organizations. They actually have logo usage guidelines, and you cannot, and I know we got into this, I don't even remember who it was, but somebody was trying to make essentially the FDA type shirt, and they actually used the FDA logo, and that's a big no-no. There are very harsh monetary penalties for using a federal agency logo to promote your product, and I think the FDA would have a decent argument that that's exactly what's happening here. And if that is what's happening, you no longer have to worry about a lawyer like me sending you a cease and desist letter. You have to worry about getting a show cause order from the FDA and from a federal judge as to why you shouldn't be fined hundreds of thousands of dollars. And that's not just as simple as going out of business if you're a company and get hit with a judgment. That's a matter of a federal judgment against you. That's not good.
So long story short, don't use the FDA logo on things. Not only will it get you in a lot of potential monetary problems, it's really not a smart thing to do in the industry.
Plus, once the FDA does start regulating, there's a decent chance these guys might be the first people to get a letter. No, it's not a crime in that you're going to go to jail. It's a civil penalty that can be, and I don't remember the amount, but it is a civil penalty that can be imposed against you for misusing a federal logo. They make the laws, so they get to decide what goes in them.
Right, and guess what? They've got bigger and better lawyers than most other folks have. So, yeah, don't try this at home, kids.
No, and actually, it's a decent point, Stefan, because one of the things that makes most trademark cases settle is the fact that all these companies are paying lawyers like me on an hourly basis to send these letters, and at some point, it just doesn't, even from a plaintiff's perspective, it doesn't make a whole lot of sense to spend a couple $100,000 trying to shut somebody down, just like it doesn't make a lot of sense from a defense perspective to spend a couple $100,000 knowing that at the end you're probably just going to have to change your name. It's the reason that 98% of trademark cases settle, because there's not a big pot of gold at the end of the rainbow, and you're in a position where if you just change your name, it's probably cheaper than defending the case. But if you're dealing with going up against the federal government, they don't pay their lawyers on an hourly basis, and they've got a lot of them.
Your tax dollars at work.
That's right.
My internet tonight is atrocious.
We know.
It's really bad.
At least we're having 1/3 of the technical difficulties. I think
right,
the bomb
well, yeah.
jinxed it.
How about this? This is a nice, simple image, right?
It is, although there's probably a baseball team in California that might get a little bit mad at you.
Mm-hmm.
I actually don't know. I think the Dodgers have that logo trademarked, although I'm not 100% sure, because you do see that on other Los Angeles stuff. That one I'm not 100% sure on, but I still wouldn't do it.
Yeah, that one's pretty blatant, I think. The next one, the next one is kind of the neighborhood favorite. I live right next to Wisconsin, so a little bit of PBR in your drip tip or your drip top.
Oops.
Yeah, and that's actually becoming somewhat more common for people to literally just take logos that are out there and incorporate them into their products. And well, you can't do it. I mean, it's just as simple as that. I mean, that is incredibly blatant trademark infringement, and that's there's no question there.
Right. I mean, that's just straight taking the PBR logo and dropping it on there. Although it does make me wonder of who holds the various copyrights on all of the meme photos that we use every single day.
I think they technically would fall under fan art, right?
You know, I know that a lot of
not necessarily. Somebody probably holds a copyright to it unless they.
Yeah, I mean, pictures and copyrights are a whole other issue that's out there, and that's actually probably the one area of copyright law that could come into play, because there are a lot of companies now that will just go in masse register all of their photographs on their website. And register them with the Copyright Office. When you do a big mass registration like that, it's pretty cheap. It's like $75 a picture.
Yep.
And copyright is different from trademark in that there are statutory damages for copyright infringement, and
right.
it can be as little as $750 or as much as $150,000. And the courts haven't really come up with a good interpretation of what every instance of copyright infringement is. Most of the courts have taken the position that it's a picture-by-picture basis. Some people have made the argument that every time you get a unique visitor to your website, that's a separate instance of copyright infringement. So pictures are a whole nother world. Be careful with the pictures that you put on your website. Make sure you have the right to use them, or make sure that they're open source pictures, because copyrighted photo. I mean, I probably spent the better part of 6 months of my life doing nothing but tracking down people who were infringing on a client's copyright, who had tens of thousands of photographs copyrighted from their website. People were just ripping them off left and right. And I will tell you that ended up being a very profitable exercise for my client, because these people know that they're going to get tagged, and unlike trademark, where you're not going to get monetary damages for the most part, copyright you absolutely will. I mean, just ask Pharrell Williams how that worked out.
Right.
Hey,
I actually registered pictures of my office, because the number of infringers out there over the years. I can't even count them anymore. At some point, I got so fed up, I started a website, officethieves.com, and I just started shaming them.
Yeah.
For the record, also for the record, I would just like to preemptively say that any of the images that you're seeing tonight, I'm claiming fair use because this is for educational purposes.
Exactly. Yes.
We are not intending to steal your crap, but I am your stuff.
Well, and it does bring up interesting issues because, I mean, there's all sorts of different things that play into it, down to what happens if you retweet somebody else's picture on Twitter. Well, Twitter actually has that in their terms of use, that you're granting to Twitter and all of Twitter's users, the entire Twitter universe, the right to use pictures that you put up there as long as they're properly attributed to you. I'm from beautiful St. Louis, and if you remember, we had a little bit of civil unrest here last year.
Mm-hmm.
And when all that happened, some of the pictures that the local newspaper photographers took started going all over the world, and those guys were all over Twitter, rightfully asking for attribution for their work, because they weren't just getting retweeted or quoted; they were getting put out by other people, and technically, if you're not retweeting it or quoting it, it's copyright infringement. If you don't have the right to use that, photo. Now, will you ever get sued? Will you ever get caught? Probably not.
Probably not.
Yeah. And that's the other reason why this is starting to come on the radar, is that vaping is becoming a pretty big industry. So, the people that are going to get caught are going to be the big players. It's the reason that you've seen Fusion's a good example. I don't know if any of you are familiar with Fusion. They changed a bunch of their names about a year and a half ago, because they had like a Magnum PI, and they had a Chuck Norris blood. They had 5 or 6 of them that were very clearly just named after other people or named after other things, and I don't know if it got prompted by a letter that they received, or if they just decided to proactively do it. But they've now changed all of their names to get them away from things that may be problematic. And it was because Fusion got bigger. When they were a small company, it wasn't an issue, and then they got bigger, and they started getting on people's radar screens, and that's what's going to happen.
Right, and that's what's going to happen with liquid companies. Is what's going to happen with businesses in this industry, because if you don't get your ducks in a row when you're starting small and you actually aspire to grow your business big, any form of trademark infringement is like putting out an entire minefield for yourself. Why would you want to do that?
I mean, most of these companies are running on, they're new businesses. They're running on pretty tight margins. The last thing that you can really afford to do is to put 10, 20, 30 grand into just having to deal with responding to the letter and changing your name. And that assumes, by the way, that you don't actually get sued. Because if you get sued, to take these cases through trial, you're talking about hundreds of thousands of dollars. That's not something that a new business can take a hit on.
Right. Plus, of course, there's also not just the infringement part where companies in this industry are infringing on the intellectual property of others outside of the industry. I know at least of a dozen cases where the company name in the vapor industry is taken by another company. So you end up with 2 that are either identical or very much the same. And so my advice is also for vapor companies that trademark your name. Trademark your logo.
Absolutely. In fact, there's one that I'm trying to pull up right now. This is kind of a popular one that is going around right now. Somebody actually obtained the trademark on the phrase vapor lounge.
Really? Wow.
They did.
Whoa.
And let me see. Do this from a different place, but they obtained that trademark, and now they are actually going out and sending letters to other companies that utilize Vapor Lounge as part of their name. Now, if you think about it, in our vernacular, Vapor Lounge is about the same as bar and grill. I mean, it's basically a generic name, but not everybody thinks of it that way. And when you talk about trying to get through the USPTO, they have absolutely no idea what this industry is. So they think it is something unique, and they go ahead and grant a trademark on it, and then all of a sudden, now they have that. And will they ever actually sue anybody on it? I don't know if they will or they won't. If they do and they take it through, they're probably going to have a pretty difficult time convincing someone that that's not a generic name. But it sounds really good in a cease and desist letter. And you know what? If you send out 200 of those cease and desist letters to vapor lounges across the country, and you talk people into changing, half the people into changing their name, and you talk 10% of them into paying you a little bit of money, you probably end up making some money on the deal.
Right, and
so,
looking at the actual filing, they apparently started the filing in April in 2012.
Right, so it was filed May 11, 2012. It looks like.
Right, in May. Mm-hmm.
And they got the trademark. It looks like with pretty much no opposition from the trademark office in December. They got it on Christmas. Well, yeah, it's because it runs off of days. But yeah, I mean, it's owned by Vapor LLC, which is an LLC up in Washington State. So. And they are saying that they've been using that name since 2009. So they have that trademark. So it goes to show that not only your product names, but also your store names, you have to put some thought into it. You can't just call it, Best Vapor. Come up with something more unique. Again, not only do you avoid trademark infringement, but you start building brand equity of your own.
Right. What I see a lot is that if you take a business name that has a certain portion and ends in vapor or vape, you'll see other businesses that take exactly the same first portion of the name and turn it into vapes or vapors. And yeah.
Yeah, it happens all the time. I mean, that's, again, I don't want to criticize any companies out there, but it just shows a little bit of a lack of creativity in coming up with the name of your business. And think about it not only from a defensive perspective of being able to avoid claims by others, but think about it also from an offensive perspective. If you just call your company, and I'm just using this as an example, Best Vapor, and it's VAPOR, and somebody else comes up with Best Vapors, are you really going to be able to stop them?
Right.
Probably not, because that's a pretty generic name that you've come up with. So put some thought into it and come up with something unique.
Right, or otherwise end up spending a lot of money and not getting anything in return.
Yeah.
So speaking of things that are or are not unique, how about this one? Let's just cut right to the chase and use the brand we're infringing upon in the advertisement.
I don't see any problem with this one, Jason. This one looks fine to me.
Well,
no, this one's bad. I mean, listen, they were at least creative enough to take off the back PLE, but I mean the color scheme is the same, and I mean this is so egregious that this is kind of a lawyer's dream, because when you file this lawsuit, typically your Exhibit A would be your product and your Exhibit B would be the infringing product. But they've already done all of the work for you here because they put it all together in one. So as a lawyer, you only need actually one exhibit here, and that'll make your case for you.
Well, and especially when you consider that the bottle design for the e-liquid is actually just the same basic principle as the old Snapple bottles.
Yeah, I mean, I guess we should give them a little bit of kudos here. It looks like they may actually have child-resistant caps. I'm glad they didn't go with the Snapple-style cap on the top of the e-liquid, but that's probably about all I can give them credit for. And this brings up an interesting point because some people would say, well, Snapple has a trademark presumably on tea and drink products. And vapor products are not intended to be drank. They're not intended to be consumed. They're intended to be vaped. And so, aren't those two different areas? Why can you have a laundry detergent and a trucking company that are named the same thing, but you can't have these two that are named? This is the equity of somebody else. And this also completely forget about trademark infringement here, and let's just think about, Stefan, I'm sure that you would just love it the next time you're at a California state meeting here, and somebody brings this one out. Not only do they get to talk about marketing to kids, but they also get to talk about the possibility of accidental poisoning.
Yep.
I mean, when you're putting a drink label on your e-liquid bottle for a product that is absolutely not intended for ingestion, what are you thinking?
Yep, this one has more going.
Companies.
Right, but this one definitely has more going for it than just the trademark infringement. And to be totally frank and honest, I would not have a defense for that. I would not have an argument. The only argument would be, yes, senators, I'm sorry, but there's a bunch of really dumb people in our industry. That doesn't work either.
No, I mean this just has bad idea genes written all over it. There's no defense for this one from a trademark perspective or from an advocacy perspective.
Right, and there's a lot more than these out there. I mean, Jason just grabbed a handful of samples, but we could probably come up with dozens and dozens.
Yeah, honestly, this is the stuff that I found in just generally being around vape groups on Facebook and Instagram for the past week.
Yeah, and there's a ton of them out there. One other thing that we should probably talk a little bit about, because I know that it made the rounds several months ago, was the HANA lawsuit against some of their cloned products. And because I think there's a little bit of misconception about it.
Wait a second. Oh. It's time for the controversial part of the show. Let's talk about clones and authentics. That's always a good laugh.
Am I supposed to call them clones, replicas, counterfeits? I don't know what I'm supposed to call them.
Well, and that's something where where really the definition is it depends, right? Because a clone, a true clone, is a different thing from something that could be qualified as a counterfeit.
Yeah, I mean, you could get into name games all day long. Ultimately, at the end of the day, to me, it always comes down to, are you utilizing someone else's proprietary information or proprietary logo or name, or are you just making it look like another product? Making a product look like another product probably isn't an issue. I mean, for the most part, every box kind of looks like every other box. Every mech kind of looks like every other mech. They all kind of draw from each other. That's not the problem, and that's not what Hannah took issue. What Hannah took issue with, what they took issue with, was people utilizing their names, utilizing their logos, and it was pretty blatant. I mean, the true one-to-one, call them counterfeits, call them clones, but I'm talking about the ones that have the logos on them. I'm talking about the ones that you cannot tell the difference between one product and another. If it's a registered trademark name, and even if it's not a registered trademark name, it is trademark infringement. you are, again, it's really no different than Snap and Snapple. You are trying to trade off of someone else's brand equity to sell your product, and you cannot do that. Now, the misconception that came in from that case was there was a judgment that was entered, but it was a default judgment. So most likely what happened was the company that they sued had probably gone out of business, would be my guess, and they didn't even answer the lawsuit. And when you don't answer the lawsuit, then the plaintiff can ask that you be placed in default, and they can ask for a certain amount of money to be awarded against you. It doesn't mean that Hannah actually proved that they had been damaged in the amount of $300,000. That was just the amount that they convinced the judge to put on the default judgment because there was nobody there to fight against it. So, yes, they got tagged, they got sued, they got a big judgment against them. My guess is they're out of business, and it probably wasn't. That may not have been the only reason that they went out of business, but certainly if you get a $300,000 judgment against you, that's certainly going to nudge you in the direction of going out of business. But that's not the first, and it's not going to be the last. Really, in general, my advice as it relates to these clones, counterfeits, replicas, whatever you want to call them, is don't use the name. If you want to make it look similar to the product, that's probably not that big of a deal. Change it some, and again, use it as an opportunity to build your own brand equity. Come up with your own name and put it on there. People were calling them the Cannas. Why are you calling them Cannas? Call it something completely different, and then all of a sudden now you have your own product that you can kind of brand around, and you don't have to worry. Hannah is going to sue somebody that's using the Hannah name. Hannah very well might sue somebody that's using the Canna name because they're still pretty darn similar. They're not going to sue somebody that's using a name that has absolutely no relation to it. So, I know that that's a huge segment of the market, and I'm not going to get into whether or not it's right or it's wrong, but, just because some kind of best practices to avoid getting sued on those, because there's a ton of trademark infringement in that area as well.
Well, and I think too we could talk about because Hannah wasn't going after the manufacturer because the manufacturer is in China, and China doesn't really, I suppose, respect would be the proper term to some extent. Trademarks and copyright and all that fun stuff from a lot of other countries because of if I remember correctly, they're not a signatory on this massive intellectual property treaty thingy. That's the technical term.
I think it's thingamajig. But listen, even if you could go after a company in a foreign country, which would probably be incredibly cost prohibitive, the way that these manufacturing companies are set up is you can stop the one factory, maybe, but the factory next door is just going to start popping them out the very next day. So the way that most American companies go about it is that they go after the American reseller of the foreign product. Because also keep in mind that if a product is not being imported into the United States, then it's not trademark infringement in the United States. So it has to come in to our shores in order to be trademark infringement. Now, some of those Chinese companies may be direct importers. A lot of them probably go through forwarders or through wholesalers or things like that in China. So now you're trying to track down the whole supply chain. Why do that when somebody's putting up a website and saying, hey, we've got a Hannah clone and here it is and here's the name on it and everything else? So there's really no reason for them to have to do that when they can just cut it off here in the States.
Well, and one of the other, I think, major issues, I shouldn't say major issues, but one of the other things that does happen is that if you have one of those sort of unscrupulous shops that is attempting to pass off these replicas as an original. So if somebody has a Hannah box that has the logos and it has some screwed up chip in it that doesn't work properly and all of that, but they're selling it as a Hannah, that's a whole different ball of wax.
Well, and it's one of the reasons. I mean, listen, I think some people would probably paint, and we're just using Hannah as an example. I know nothing about the company other than I read the lawsuit, but um, a lot of people try to paint them as trying to shut out competition or other things. In addition to people trading off of their own brand name, which absolutely will hurt their sales, there are safety considerations involved in it as well. Because, when I put out, let's use Stefan's example. When Stefan puts out the Didac atomizer, he makes sure that it is 100% the best quality. And if somebody else, and they probably already have, cloned the Didac atomizer, by the way, that's going to be my new goal, is to make that a thing. When somebody clones it and it's not of the same quality, and an atomizer is a bad example, but let's say it's a mech to match hybrid, then what if that hybrid, that mech, all of a sudden vents on somebody and it's a clone, and they were told that it was a true Didac original, and so they're going to go back and they're going to sue Stefan. Stefan's going to have to prove that now it wasn't his product that injured this person. So there is some valid reason for people to try to keep out the products that have their name so that they're not associated with any of the possible negative consequences that go along with it.
Right, and there's another good reason why you actually go after infringers. If you have knowledge of people infringing on your intellectual property right and you do not act, you might actually end up losing your intellectual property.
Right, so there's a number of defenses to intellectual property infringement, but certainly if you are knowledgeable that someone is infringing on your rights and you let them do it for a certain amount of time, depends on the area of the country you're in, but it's usually somewhere between 4 and 6 years, then you might be forever barred, not only from going after that person, but if you've allowed 100 people to do it, the 101st person is going to say, well, why are you coming and picking on me? You let these other 100 people do it. So, it just kind of gets down to, it is your property and you have to protect it. Some people may not care about this at all. Some people may come out and call their liquid e-liquid, and they don't care if somebody else uses the exact same name. That's fine. But if you make the conscious decision to go after and build your own brand, then you have to also take the steps to protect it.
Sorry, I'm all quiet because for anybody who hasn't been here the whole time, I've been having extraordinarily bad internet issues tonight.
Oh, you actually sound good now.
Oh, of course I do. When I try to type instead of talk, I sound good. Got it. So the point is just to try and type the whole time while I'm talking, and then I'll speech jam myself, and it'll be a great time.
Right.
But somebody had Joey had asked if talking about different forms of advocacy, and I feel like this is in a way advocacy related, because we have, intellectual property infringement within the industry is such a huge issue at this point. We showed some of these examples earlier that they're just blatant. It's not even, there's no way that somebody has no idea that this is not okay to do. And the more and more we see of this, the more and more you're going to see senators holding up your bottle of liquid or your mod that has the fucking Autobots logo on it. Mm-hmm. You're going to see these things. And right. And this isn't even a matter of marketing to kids or anything like that. It's how do we appear as an industry?
Yes.
Right now, there is a perception that, and it's not wrong either, completely, that for the most part, vapors do not respect intellectual property rights. And right. I get it. A lot of us, probably the majority of us, are from the internet generation, where if you download where we all download cars regularly. But it really is a thing that we need to get under control, and it's something that I feel we need to self-police. personally, and I don't, you do what's right for you, but for me personally, I typically will not spend money with companies who do this sort of thing.
Yeah, and listen, I think one of the things, this kind of ties together both what I do professionally and personally, but one of the things that I try to do from our advocacy group, from Brave, is, we're not an industry organization, but I don't think there's anything wrong with giving the industry, giving the vendors, giving the manufacturers, a little bit of free advice on best practices so that they can kind of help themselves and be better industry citizens.
Exactly, and the other thing is that the industry already is sort of looked down upon in terms of like, oh, it's like all these weird head shops selling e-cigarettes, and you don't want to perpetuate that perception any further than you have to. So yeah, at some point everybody needs to get their act together, because this is not helping anybody.
I mean, from an advocacy perspective, the more legitimate of citizens that we are looked at as, the better it is. And this is just another step in trying to legitimize the business aspects of this industry.
Exactly. We're businesses. We should behave in a professional manner, and it's one of those things that I encounter it a lot. Half of the time, I actually spend my time educating businesses on what it's like being a business. And trademark infringement is one of those things that comes up a little too often.
Yeah, absolutely, and I think that's that's really where the goal of this particular episode is just to highlight that this is happening, and that as we contribute to it. I mean, don't get me wrong, I get that not everybody is going to go out and spend $200, $300, $400 on a mod. Absolutely not. But at the same time, there are a lot of products out there that are original and that are, that maybe they're made in China, maybe they're a low-cost thing made in the U.S., but I do think that there really isn't a great reason at this point for a lot of these replica devices to exist.
And I think a lot of them are starting to go away. I saw a lot more device issues probably 12 months ago. Right now, the big fight on the IP side is absolutely on the liquids, because there are just so many out there and so many different startup companies trying to fight their way and become the next big thing. And in addition to having good manufacturing processes, having good packaging, having a good name, having a good name as part of that, and having a good name means not only something that is memorable, but something that you're going to be able to use for the long term. So it's just part of building your business.
Right. I mean, it's ultimately like we as vapors all need to be, as on the consumer side, we need to be responsible about how we're acting and what we're doing in the public eye and that sort of thing. But businesses, it's almost more important, because that's, for better or for worse, that's where a lot of the government action tends to run. They're not directly targeting consumers with most of this legislation. It's really targeted at the business.
But I think from an advocacy perspective, the biggest take-home message is to inform other vapors and to inform vendors about this issue, because the faster that we can get this issue cleaned up, the faster that we can stop having to answer questions about names that are marketed to kids, or names that are clear ripoffs of other products out there. All this does is if we can get this issue cleared up, it's one less thing that we have to fight, and God knows we have enough issues to fight.
Right, and this should be something that should be easily dealt with. I mean, this is not related to long battles, state laws, and regulation. This is like basic business 101.
Yeah, absolutely. And as John said earlier, I mean, build your own brand. You know, you're not going to survive in the long term as a company if you're trying to build your business on someone else's branding. What you're really going to find is that, number one, your sales will peter out very quickly because you'll be a novelty. So you may have great sales initially, but what happens 6 months down the road when they start to falter a little bit? You don't have your own brand to back that up, and instead what you have is the shell of someone else's brand that you've used, and now you're being put out there by public health as an example of why vaping is bad for some reason.
Right, or what if you're infringing on the style, the design, and the name of, say, a beverage company, and all of a sudden there's this massive scandal out there about something being poisoned. How's that going to affect your copied brand? Why would you want to inherit the risk?
Yep, and I think too that it's about, you know, from the business perspective, and to kind of loop it back to advocacy, is being a responsible business owner, right? It's not about going out and making $20 million, because look, if you're already there, great. If you're just starting out, you have the same shot as anybody else, but I can tell you that right now it's going to be a lot harder to get to that level than it was 2 years ago, or to start 2 years ago. It's going to be very difficult to the market at this point in the game and get big quick. And I told this, it's kind of like do reviews, right? The other thing that I do is taste buddies with my best friend Luke. I shouldn't just say my buddy. He's a little, you know, he's like a brother. But you don't get into doing reviews on YouTube to get like vape famous or to get a bunch of free stuff. If that's why you're doing it, I guarantee you are not going to be satisfied with the outcome. If you open a business because you want to make a lot of money, you know what, if you can make it work, great, more power to you, but that's not what happens in the vast majority of times.
Mm-hmm. Yep, exactly.
So being a responsible business owner is really just the core of this, and that extends into the advocacy arena too. If you are a business owner, you want to be able to walk out and say, hey, my products are this, they're not marketed to kids, I have this kind of signage, I do all these age checks, and there will be no question in anyone's mind that you are a responsible business owner. Being involved in your community as a business owner, you know, donating to local charities, working with your Chamber of Commerce, all of those things are part of that. There was Stefan knows all about this one, but there was actually what was it, a city or a county in California that actually honored a vape shop for their contributions to helping people quit smoking.
That was Ready Set Vape. They got a proclamation from I think it was the County Board of Supervisors for all the great work that they've been doing. And here's the thing, I know Ben Jewell from Ready Set Vape. He's actually been at it for a very long time, and instead of just running his business, he met with his legislators, he met with the local authorities, he's part of the Chamber of Commerce. I mean, he does all these things in the community. So logically, you're automatically elevating your business to a slightly more respectable level, and eventually these things pay off.
Yeah, and for anybody who's maybe heard of him, maybe I don't know if you have, maybe you have, maybe you haven't. We actually did for Taste Buddies. We actually did a review, or not a review. We did a review of a business owner. We did an interview with Benny Muhammad, who's one of the shop owners out here up in St. Cloud. And Benny, man, that guy puts so much time and effort into everything. Like, his business is pretty much his life. The guy spends almost every day of the week doing some kind of function with the Chamber of Commerce or the local businesses. He's actually got it hooked up with a local clinic that refers him customers to help them quit smoking. And Benny, in the recent hearings, he was talking with the Chamber of Commerce people because he spent 2 years building up that reputation, and that netted him the head of the Chamber of Commerce for his city getting in touch on his behalf with his state representative and saying, "Why are you trying to shut my guy down?" You can't buy that kind of help. I mean,
No, you
to
can't.
a point you can because you're paying for membership in the Chamber of Commerce, but you do have to put some effort into it. But that's the kind of things that, as a business owner, you need to do. You have to realize that we are in, all of us, a high risk industry, whether we're a consumer or not. And that's why one of the things that both Stefan and I tell people when they're on the fence about do I want to put money into something like SFATA or Smoke Free Association or whatever else. This isn't about you're spending money on no return, right? This is like paying for liability insurance. Or paying for the electricity to run your shop. These are things that you really need to be doing, and to whatever extent you can. I mean, I'm not if you're running just a bare minimum profit, then yeah, okay, I get that you can't drop a few $100s every month to pay for a lobbyist. If you're still running in the red, I get that too. There's other things that you can do. You can engage your customers to get them to do the advocacy on your behalf, or you can make sure that you're working in your community to get people active and help them send emails. Shit, we have a couple of shops here who have set up computers in their shop to make sure that people can send emails for calls to action. They just drop a computer on a table, say, here you go, log into your Gmail, go hit this thing, log out when you're done, and there you go. Maybe we'll give you 10% off. And Joey actually brings up a really good point, and I don't want to put anybody on blast here either, because that's not what we're trying to do. But and this one goes for both consumers and businesses. If you're attending a hearing, and it doesn't matter if it's a city council, a senate, or a state senate, state house, or anywhere else, the last thing that you want to do is, for lack of a better term, break the rules. Shouting out things in the middle of a hearing is generally frowned upon.
Yep.
Doubly so when there are things that may be offensive to some people.
Yep, and to make matters worse, it took me 2 days in total time dealing with the media and every article that was out there that had to, of course, mention that there was a heckler who was shouting at the senators.
Right.
Thank you for all that wasted time that I could have used way better. Yeah.
Yeah, and that's the thing is understand that for the people who are going out and kind of heading things up a little bit, when things like that happen, you're creating work for other people, and it's not work that those people are going to really appreciate doing. I think most of us in the advocacy arena are happy to do the things that we know need to be done. We're happy to write emails. We're happy to help people write emails. We're happy to coach people on how to speak in front of a city council. I am happy to do all of those things for anybody who asks. But if you ask me to clean up your mess, I'm not going to be quite as happy about that, because that's, for one, I'm a volunteer just like Stefan, and if I'm cleaning up a mess that you made, that's my time spent on something other than myself. Not to be greedy, but that's what it boils down to. I'm spending my personal time on cleaning up a situation that someone else created because they couldn't keep their mouth shut for 20 minutes.
Well, and I think that kind of comes back to the central point of tonight. What does this have to do with advocacy? we as advocates need to work with the vendors and work with the companies and vote with our dollars as to the companies that aren't going to make this even more difficult for us. If we go to a hearing and have to deal with the lineup of products that you put up there earlier, Jason, the rest of what we say is going to sound like your mic did when you were cutting out earlier. Nobody's going to hear a damn other thing that we say other than us trying to backtrack and deal with all of those other issues. So, it's just some good proactive medicine to avoid further advocacy fights.
Absolutely. I don't think I could have put that better myself. So what do you think, guys? Do we have anything else we want to bring up or chat for those of you who are still with us? Anything else that you would like us to chat about tonight?
Well, I do have one last link regarding trademarks and copyrights, and I'll just post it in chat here. Do not ever expect that if you're infringing on anything, you will be treated as nicely as Jack Daniels treated the author of a book. Instead of sending a regular cease and desist, they sent a cease and desist and said, "We're going to be happy to pay for you to change your cover on the next edition." That was rare, and that was a publicity stunt. Don't expect it to happen to you.
Yeah, that's not the normal way it happens.
So have you ever considered starting a marketing firm while doing the actual trademark stuff? Because I think there's good business in it.
There's a treasure trove of kind of funny trademark cease and desist letters out there. Let me drop this one in here. This is one of my favorites that Starbucks sent over Frappuccino to a microbrewery here in the St. Louis area, and the response is pretty funny. But I don't think that the response and the enclosed check for $6, this is certainly kind of the exception to the rule. These should be treated as serious things, and if vendors do get these, they really should work with attorneys to get the proper response back. I'm not trying to make work for all of my brethren, but they really do need to take these things seriously, because if a lawsuit is filed against you and you don't respond to it, you can have a judgment entered against you for hundreds of thousands of dollars.
Right.
But nevertheless, there's some levity at the end. I mean, the Starbucks letter is just kind of a standard cease and desist letter. I've seen thousands of those, but the response, which is included in the embedded PDF, is pretty funny. So.
Right, and the other warning is sort of outside of the scope of trademark stuff, but since we're actually on the topic, a lot of small businesses that are started by pretty much one person with nobody else part of the corporation, they tend to incorporate as an LLC, and they believe it will allow them to have a certain level of protection and actual limited liability. Nothing could be further from the truth. If you're actually a single person LLC, whether or not you've got some employees, they could basically pierce the veil and come after your personal assets. So don't rely on the fact that you've registered an LLC as being any form of protection against lawsuits, trademark lawsuits or otherwise.
Yeah, it does, depending on the state, it does provide some additional protection, but you're absolutely right. More and more courts are just looking right through, especially single-member LLCs, and just going right after the principles. It does provide some level of protection, and it's better than running it as an unregistered entity.
Oh, sure.
But it's certainly not any sort of, panacea from protection.
And to flip topics just a second, there's a little bit in chat that I want to talk about here really quickly, because this is actually something that I think we tend to gloss over, because honestly, some of us take it for granted and we just do it naturally. But some of the folks in chat are talking about, dressing up when you go to city council meetings, to hearings in your state legislature, and all that sort of thing. That is absolutely a good idea. In fact, it's not even a good idea. I would dare say that it's required. If you walk in with a group of 50 people wearing jeans and hoodies that are all covered in vape logos and everything, you really can't expect to be taken seriously. Now, that's not to say that everyone needs to wear a suit, because not everybody owns a suit, let's be honest. But even if you don't own a suit, chances are you own at least one button-down shirt, and even a pair of jeans, if they're not torn up and everything, is pretty okay. A decent pair of jeans that's not torn and not full of holes, and a button-down shirt is fine, if that's the level to which you're able to dress up. Now, if you've got the wardrobe to do it a little bit nicer than that, I can't stress enough how much of a good idea it is to do that. The folks in these places are typically going to be wearing, at a minimum, business casual, right? So slacks and a polo, or slacks and a dress shirt. For women, possibly dress pants, possibly skirts, but professional-looking tops, things you would see in an office. And again, not everyone has these things in their wardrobe arsenal, but if you do, please do use them for these things. It's really, I can't say that it's absolutely 100%, going to be the thing that changes anyone's mind, but we will be looked at much better in legislation if we present ourselves professionally.
Right, and politics is all about subtlety and the minute details. A lot of people sort of don't get that, and therefore also don't quite get the political scene. But it's all about the little things.
Yeah, I mean, and it's about knowing your audience too. I mean, one of my board members on Brave, AJ Mole, and myself went down to a city council meeting in the little city of St. Clair, Missouri, about 40 miles outside St. Louis, and they were having a hearing on a smoking ban that would include vapor products, and we went down there, and we weren't overdressed by any means. We had, just dress slacks and button-down shirts on. The council members all came in jeans and polo shirts, and they were all very casually dressed. I mean, this is kind of a little bit of a rural community, but without a doubt, not only were we the two that were the best dressed, we were the two that they listened to most intently and asked us questions afterwards. If you dress for success in those types of situations, always err on the side of being overdressed and not underdressed. You will absolutely command the respect that you deserve. Now, I typically tell vendors if they want to wear a shirt with a logo on it, especially if it's an establishment that's in the jurisdiction that we're going to, I don't have a problem with that as long as it's not a ratty old T-shirt. But as far as other people, yeah, I mean, everybody's got at least either one nice pair of jeans or a pair of khakis and a button-down shirt, and just go with that, and you'll always be in good shape. If you're going to a state house, a suit is definitely something that you should strongly consider.
And even if you don't, if you have problems with ties for some reason, my experience personally anyhow is nobody's going to judge you too harshly if you're wearing a decent shirt and a coat. But you can kind of forego the tie if that's really not your style. People won't judge you too harsh on that, but do make the effort to make yourself a little more presentable than you would on a day-to-day basis. It's not necessarily going to be the straw that breaks the camel's back, but I guess I have to look at it in terms of like a risk management kind of thing. Do you want to risk that being the one thing that turns people off? The fact that you're dressed a little bit funny.
Yeah, or
And
they
not
just going to
funny,
tune
but-
you out.
Right. So, I don't know. That's all I've got, I think, tonight. I'm content.
We'll be back next week without the robot voice. Instead,
We won't be back next week, though.
Oh, sorry, no, in 2 weeks. Yes, correct. Darn, I almost pushed James aside. What the? Yes, no, in 2 weeks, and we'll be tweaking a little on the Dalek that is currently overtaking Jason. I think transformation's happening. I mean, it must be that Borg effect or something.
Hey, just because we know all about Ohm's law doesn't mean that resistance is futile.
Oh, I thought it was floor tile.
Well, it is, but that's not politically correct.
Not quite.
So with that said, everyone, thanks again for tuning in and joining us for tonight. We will be back in 2 weeks on Tuesday, hopefully within with better audio from my side of things. If you are wanting to check out the replay, you can do so at the YouTube link that I posted earlier. I'm going to post it again just for fun. It's got a whole bunch of crazy characters in it, kind of like this show, actually. And I don't know, by 2 weeks from now, we'll probably have some more stuff to talk about. I'm sure there will be some new fun legislation out there that we can chat about, or at a minimum, some updates on Minnesota, California. And guys, if you do have some things that you would like us to talk about, I would definitely encourage you to send us an email. It's going to be Attainable Advocacy. What?
I'm going to have to interrupt you. Since we now changed the schedule of the show, I'm afraid you're going to have to do that one solo, because I'm going to be stuck in Chicago at the SPADA conference.
What, you can't broadcast live?
Not sure.
Can't we just get Mitch Zeller to join the Hangout?
Wouldn't that be something? Right, yes, that was... Oh. We'll deal with that.
We will deal with that. That's actually a very good point. We'll have to figure that out, what we're doing for the next show. If I'm going to run solo, or if we might skip it, but I may run solo because I like the attention.
If it's possible, I'll try to hook up Google Hangouts to the phone, and whatever we're doing at that point. I think the conference session might have already ended at around that time, so. I might just take the phone around and have a few people say hi.
That works. We'll plan on still doing a show in 2 weeks, and we'll come up with some interesting stuff to talk about, as always. I do want to thank John especially for taking time out of his day. It's not too often that we get the expertise of a practicing attorney to talk about some of these issues with. So thank you, John, very much for showing up tonight. We really appreciate it.
Yes, thank you.
Happy to help out. Happy to talk about it. Hope it wasn't too boring. I'm going to drop a link in chat to the for our Twitter handle for the Brave Advocacy stuff. Follow us for anything Missouri and Southern Illinois related.
Yeah, absolutely. And you can find Stefan Didak on Twitter at Stefan Didak, or one of his other. You can find me through either at MNVapors or at Vapornaut. And if you would like to see the little bit even less professional side of me, you can also check out our channel at youtube.com/users/tastebuddiesreviews. So there's all the plugs for the evening. Thanks for joining, everyone. And I don't know, I'm feeling a little squirrely tonight, so I think we're going to do a post-show hangout as well. So I'll get that up and running, and I'll drop a link in the chat.
Sure. So you guys...
Oh, yeah, that's right. I have to hit this big red button that says Stop Broadcast.
Well, unless you just want to keep going.
Live hangouts, yes. All right, guys. We'll put a link in the chat for after show in just a minute here. Thanks again.
Thanks, everybody.